You're watching News First Weekend Primetime News. Time now for Action TV.
The issue pertaining to government school students being charged money was debated at the recently held cabinet meeting as well as in Parliament. However, the manner in which some government officials approach this issue is truly humorous. The Cabinet of Ministers had decided to formulate a circular which bans the officials from charging money from students. However, the humorous fact is that while steps are being taken to formulate a new circular, officials have taken no steps to monitor whether principals and other officials of schools are adhering to the circulars in this regard, which are already active. Circular 17 of 2008 forbids money being charged from students who enter schools for advanced level classes. Circular 19 of 2012 forbids money being charged from students who are enrolled for grade 1 classes. Circular 37 of 2008 forbids money being charged from students who are enrolled for grade 6 classes and students who are enrolled to classes from grade 2 up to grade 11. It is saddening that so many circulars have to be issued in a country where education is considered to be a free service. Even in such a backdrop, school officials freely charge money from students, and one would find it difficult to find parents who had not been confronted with this issue. There is a sharp increase in reports of officials charging money from students showing no regard for the government circulars after individuals who have plenty of experience in hoarding wealth through education reach the echelons of governing free education. One such official defended the school authorities charging money from students during a function held at the Nellore National School. This took place in a backdrop where parents of this school protested against students being charged 1,000 rupees each to organize the said function. Quoting official records, Action TV revealed that money collected from students in this manner were utilized for many unnecessary purposes, including to purchase a suit of clothes for the principal. However, even after such revelations, education officials made sure that they took no action against the perpetrators of this incident. Incidentally, when considering the allegations of fraud leveled against the government sector, a majority of the such complaints involve officials charging money from students. Such allegations were also leveled against a former principal of a leading girls' school in Colombo. However, she was allowed to leave the country and officials swept the investigation into her actions under the rug. Later on, educational officials appeared on national television to argue on behalf of charging money from students along with the said former principal. Taking such facts into consideration, one should note that in order to protect the fundamentals of free education, officials should change their attitude of protecting wrongdoers who occupy positions of authority instead of merely restricting themselves to issuing circulars. A debate in this regard arose once again due to the enactment of the law in relation to a case pertaining a 13-year-old child in the Horana area. Issuing a media release yesterday, the police media spokesperson noted that the 13-year-old child charged for collecting 8 coconuts is an offence which is punishable under clause 367 of the Penal Code. The release noted that in accordance with the law, the Horana police produced the child before court.
A person who is under 16 years of age is arrested for any offence. The officer in charge of a police station is bound to act under the provision of section 14(1) of the Children's and Young Persons Ordinance. The provision says if that person, that means a child, has committed any offence which is not amounts to the provisions under the schedule of the said ordinance, he is bound to release the child to the parent or the guardian on a surety bond.
This legal advice was given by a retired Chief Inspector of Police who headed the police unit attached to the National Child Protection Authority. This officer has a distinguished career and had in fact collaborated with the Scotland Yard to apprehend a child molester and single-handedly handles the court proceedings against the suspect in a London-based court.
An offence which amounts to a theft will have to investigate in depth whether he has committed that offence dishonestly, because that is the most valuable ingredient that we'll have to look into. Otherwise, if he has committed such offence, we can't ignore the provisions under Children's and Young Persons Ordinance, especially under section 14(1). Because the police officer who is making an investigation, the officer in charge is bound to act under that provision.